For the Honourable Mr Ruinui.
Thank you, Mr Chair. I find it very interesting that different members of the Māori Party have different versions of the history of this particular bill. And I'd have to congratulate my colleague, the Honourable David Parker, in his speech to the House this afternoon. See, Mr Speaker, we are talking about the preamble to the bill, but it's in terms of the history of this particular bill. But in doing that, we have to be mindful of those matters that were raised throughout the Select Committee process that aren't actually covered in the preamble. And I heard the interjection from the Honourable Tau Henare, and I wonder at what point he's going to take a call and explain to the House what instructions he had to drive this legislation through the Select Committee, not taking any consideration and anything into account in terms of the views of the submitters, because, Mr Speaker, I was part of that process, as I was part of the 2003-2004 process, and I have to say it was an absolute shambles. And I'm actually disgusted with the interjections I'm hearing from the member from across the House in terms of his understanding of the process. If he thinks it was a transparent and open process, he should go back and read the committee's report, because some of the issues raised, a lot of the issues raised by the submitters are actually not included in the report. And that was because that member went out of his way to shut down any open debate on certain matters. But, Mr Speaker, I'm sure he was acting under orders, so we'll leave that matter as it rests. Mr Speaker, we had some valuable contributions this afternoon for and against this bill, but, Mr Speaker, it's important that we take into account what the common people were saying about this particular bill. They weren't interested in the high-flying legal arguments around customary rights. And I should remind the member from the South Island that any codification of customary rights, as this is attempting to do, is actually an extinguishment of those customary rights. Get it clear, you're a lawyer, I hear. So, Mr Speaker, when you talk to people on the street, the first question they ask you is, what is this going to deliver in terms of recognition of the customary rights that they have enjoyed since 1840? I have to say, well, there's a lot of uncertainty around it. There's a lot of uncertainty around it because a lot of the areas which the government claims this bill covers are customary rights they enjoy already. And I'm quite offended when I hear the member, Rahui Kātane, refer to the taking of shellfish, the collection of shellfish, a manaakitanga that Māori have for other people, because those issues have never, certain principles have never been compromised at any time in my recollection, apart from the Fisheries Act 1991. If she wants to talk about the history of this particular bill, I say to her, go back there and have a look as to when the customary rights in terms of shellfish collection or fisheries is concerned, where they were actually extinguished. They were extinguished back then, but to our benefit, because the codification of our customary rights in terms of Moana was very, very clear, and that we have those rights, or certain rights, still in place that allow us to practice manaakitanga. So another thing that annoys me is how we put up these arguments and put these issues before our people, and now people think, well, they can look out the window one day and the Takutai Moana is gone. I'll give an example. I visited a group on the weekend in Maketu, and the issue around this particular bill came up. And a certain person, out of genuine concern, got to her feet and asked me, what's happening about the Takutai Moana and our kai moana? I said, well, we're standing on the Takutai Moana, and it's still here. It's still ours. And then we just had lunch, and we had kai moana on the table, so what is actually your issue? And her issue was saying that there was a lot of hype and emotion around this bill, as there was in 2003 and 2004. And the concerns that were raised amongst the Māori people is that those rights, in terms of the customary practices, would be extinguished forever. That is not the case. That wasn't the case in 2003 and 4, and it's not the case now. I make the accusation here in the House, Mr Speaker, that the problem in 2003, 2004 was that certain people in this House raised expectations about what they could deliver if they were formed a Māori party. They raised expectations about what was possible in terms of taking their issue to the High Court, raised expectations in terms of what enjoyment they would have into the future around customary practices. In other words, Mr Speaker, there was a lot of hypocrisy and misinformation being flouted out there amongst Māori people. And that misinformation is still out there. It's still out there, and they The Māori Party is saying, Mr. Speaker, Mr. Chair, sorry, Mr. Chair, and those people are actually expecting the Māori Party to deliver to them customary rights and customary title. Now, they forgot to cover the issues around the complications they will face with the High Court. And, Mr. Speaker, my colleague David Parker said it earlier on that the benchmark is very high in terms of qualifying for the recognition of customary rights under this bill. Now, that may be all very well for the legal fraternity because, let's face it, they will be involved in litigation for some time to come, and they will be handling these applications on behalf of many iwi around the country. But what they're not saying to those iwi is that once they get this bill through, the issue is not over. It'll never be over. It's just beginning, because the difficulties for iwi who are applying for customary title over the Takutai Moana will have to meet the legal costs. They will have to provide strong evidence about those interests, and that Māori have never ever had to do, ever. Since 1840 and pre-1840, they've never had to do that. I want the member to think about that and what sort of situation they've created for Māori in terms of arguing their case before the High Court. Never ever had to be done in the past. The previous Labour government gave Māori the opportunity to enter into direct negotiations to clarify the nature and extent of their customary rights on the foreshore and seabed, and many of them had taken up the offer. Now that has been removed. Neither can they go to the Māori Land Court to have those hearings. And the Māori Land Court is probably the best court in the land to consider these types of applications for customary interests, because their people are more intricately involved with Māori on a day-to-day basis. They are community-based people, a lot of them themselves. And so, Mr. Speaker, it's a shame that we didn't have a longer debate around this particular issue. I will concur with my colleagues that it was rushed through a select committee process. We made that known at the time, but there seemed to be little consideration for a longer debate. And, Mr. Speaker, that's just got to be something that, Mr. Chair, that is something that the Māori Party are going to have to explain to our people in the future. An interesting submission in Tauranga was that this provided the opportunity for us to have a longer debate. Little did he know, this was the opportunity for the government to shut down the debate. Because once the bill came into the House, we go through this process, the third reading process, that is the end of it. There is no debate after that. And that's why Mr. Tauhena, the Honourable Tauhena, acted on instruction, because they wanted to shut it down forever. There is no ongoing debate for Māori in terms of the legal requirements around their customary interests or the nature and instinct of their customary interests. Thank you, Mr. Chair.
Kelvin Davis.
Thank you, Mr. Chair.